there's always a story. There's always some sort of story that you can be telling in your case to make it more compelling and to make it relatable to the people that are listening, whether it's the judge, whether it's the jury. Your client should be authentic. If they're going to get emotional, whether it's at their deposition, whether it's on the stand, it should be authentic. If you're coaching them to say, listen, if you can throw in a few tears here and there, that would be really, really good. Everyone sees through it. Framing the story of your case, something that's very important is being clear and concise. Get from point A to point B in the most structured, logical way that you can get there while still engaging someone who's either reading your paper, whether it's a brief, or listening to your argument.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Lauren D. Frazier. Lauren D. Frazier is a nationally recognized personal injury lawyer with the New Jersey law firm of Javerbaum, Wargraft, Hicks, Kahn, Wickstrom, and Simmons, PC, where she specializes in spine and brain injuries. Lauren also works with attorneys from all over the country, helping them prepare for their own trials by facilitating focus groups and offering strategic trial consulting. Lauren is also a highly sought-after lecturer and instructor for various trial lawyer organizations across the country. She is a member of the Board of Governors of the American Association for Justice, where she is the co-chair of the Jury Bias Litigation Group, as well as a member of the faculty for AAJ's Case Plus virtual focus groups. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting, Lauren will be taking questions from the audience once the presentation is complete. So if you have a question that you'd like us to address at the end of the presentation, you can always submit it by clicking the Q&A button in the control panel at the bottom of your screen and sending it in there. Now, without further ado, here is Lauren to discuss connecting creative arts to the art of lawyering.
Hello, thank you so much, Nina. That's a really, really nice introduction. Good morning to some of you. Good afternoon to some of you. Okay, so I want to talk to you today about connecting the creative arts to the art of lawyering. By way of background, obviously, I'm an attorney. I went to law school. College, I was a liberal arts major, but my background throughout my entire life was theater. In fact, I spent most of my childhood in the green room, either getting ready for a show or doing my homework because my parents were involved in a show. So I grew up sort of in a very theatrical family, in a very theatrical environment. And so when I finally made the decision after other avenues to go to law school and then to become a lawyer, I realized that there is a true synergy between what I knew growing up and the background that I had and what I do as a trial lawyer. So I'm going to talk a little bit about that today. So by way of further background, I am a trial lawyer. I specialize in plaintiff's personal injury. And as Nina said, I do focus in spine injury cases and brain injury cases. Part of me thinks that's probably because I am I didn't make it to medical school. So this is as close as I'm getting to having a medical background. But I do find it fascinating. And I also find that the people that I'm helping truly need my help. And that was one of the things that drew me to the law in the first place. But I've been, I've done very well for myself as a trial lawyer in New Jersey. But I also branched out throughout my career. I have written and published 2 fiction books for young adults. And I have one more in the hopper waiting to go out. So I have a series of 3 books called Trinity Queenmakers. And the last one that's coming out eventually is called Rose of the Field. And I've also written recently nonfiction for lawyers. I published with Thomson Reuters and AAJ Press just last year a book called Experts that I co-wrote with my friends John Lemuro and Mark Kittrick. So I continued as a lawyer. I love to write as a kid and growing up through school. So I did continue that both on the fiction side and the nonfiction side. And that's something that I think also translates to what I do as a lawyer. So the other stuff I still do. I'm a playwright. I am the resident playwright for the Black Cat Theater Company of New Jersey. Primarily, I write comedies. I think I'm funny. My 14-year-old daughter not doesn't always think I'm funny, but I write shows for them. I'm an actor. I'm a singer, although not so much a singer anymore. I did grow up in musical theater, but I don't really sing a lot anymore. I am a dancer. I'm a director, I'm a producer, and I'm also a theater and dance teacher. So I keep myself very busy, mostly keep myself out of trouble. One of the things that I have, new activities that I've sort of picked up in the last 5, 6 years is I became the studio owner and director of a performing arts studio that was sort of going under during COVID. And I jumped in and brought it back and rebranded us. So now I have my own dance studio where my daughter dances and her friends. And that keeps me very busy. I just recently started a dance team of mostly middle school and teenagers for our local minor league professional baseball team. So as probably my bosses at my law firm always wanted to know is, how does what you're doing outside connect to lawyering? What they really mean is, how does what you're doing outside make us any more money? And the answer that, the more connections you have in your community, the more likely you are to bring in work and bring in clients, obviously. But the activities that I'm involved in, how does that connect to being a lawyer? And I've thought about that long and hard over the past couple of years, not just to justify my own activities and to justify my own existence, but I really believe that there is a lot of value in bringing your talents, maybe they're your hidden talents or talents that you wanted to develop but never did, bringing that to your work as a lawyer. So the connections that I see, really more from an acting perspective, are perspective. When we are sort of that left-brained artistic person, we see things a little bit differently than everybody else. And that's not to say that we're not also logical, that we're not also pragmatic, but I sort of see, I don't miss the trees. I'm very detail oriented, but I tend to see the forest. And so my perspective on things a lot of times comes from an entertainment aspect, meaning when I'm going to present something, whether it's a webinar, whether it's an in-person seminar, whether it's at trial, I'm presenting an opening statement or what have you, I'm thinking about there's got to be a level of interest and entertainment to it that will draw people in. So my perspective is that. One of the things that comes to mind when I think about, being an actor and having, and I do have a professional background in acting as well, is that, when you're trying to connect with a character perhaps that you've been cast as, you've got different feelings and emotions and sympathies and empathies that probably are a little more pronounced than if you were just kind of, here to say like, well, I represent Mrs. Smith. She's a nice lady and she got hurt. As an actor, as someone who has sort of a writing background as well, I'm thinking more about a story. Presentation skills. Once I got to law school and I realized I'm not afraid to talk in front of other people. I can stand up and I can present, kind of seat of my pants when I need to. That's something that, whether it's a skill that you're trying to hone and get better at, or it's a skill that you have and you realize, hey, maybe I can use my powers for good. There's definitely a difference between people who clearly have had some sort of theater background, whether it was just, your school plays when you were a kid, or maybe you were a dancer or in the band, whatever. There's less of a fear of getting up in front of other people and either making an argument or making a presentation. Doesn't mean that we don't still get nervous. It doesn't mean that we're not just sweating through our clothes half the time. But we have the ability, we know that, we'll be okay and we know how to do it. And then also there's the development of a story. For me, as a personal injury lawyer, on the plaintiff side, what I'm doing is I'm telling the story of a case, and I'm telling the story of a person who needs the help of a jury generally. But your story doesn't have to be, that. If you were an attorney that handles transactions, if you're an attorney that handles corporate or commercial litigation, there's always a story. There's always some sort of um, story that you can be telling in your case to make it more compelling and to make it relatable to the people that are listening, whether it's the judge, whether it's the jury, whether it's mediator, whether it's arbitrators, what have you. So as trial attorneys, for me, I find myself as a producer. I'm producing a show, basically. I've got to put all the moving parts together. I have to make sure the funding is there for my experts, for my witnesses. I'm the writer. I am definitely the chief writer and bottle washer. But I'm creating an outline, storyboards, however you see it. I'm creating the story that we're going to be following to make it make sense and make it relatable. I'm the director. I'm in charge of making sure everybody's in their place. I'm making sure that all the pieces are coming together, and that we can go from start to finish, and we can, produce something that of value to bring the case to light, to bring my side's case to light. And I'm also an actor. Now, I use this term very loosely when I'm talking about particularly trial lawyers. One of the as Nina had mentioned, one of the things that I do also as a lawyer related side gig is I go around the country helping lawyers with their cases by facilitating focus groups. And one thing I can tell you with great certainty is that um, jurors will sniff out inauthenticity as well as authenticity. But if you're not authentic, if you're being phony, they're going to sniff it out, and they're not going to like it, and they're going to hold you accountable for it, whatever way that turns. So I say acting, you're an actor. You are, in the sense that you are playing a role, but at least as a trial attorney, I try to get out of my own way. I used to drive a Mini Cooper, and you can't tell it from here, but I'm 4'11". I'm 5 foot. I would say 5 foot nothing, weigh 100 and nothing, and I used to drive this little Mini Cooper, and my family was horrified. Like, how can you drive this tiny little car? How unsafe is that? And I said, no, no, no. I'm like, I can get out of my own way, and I can get out of truck's way, so I'm good on the highway in this thing. Same thing as an actor, as a trial lawyer actor. You're really there to get out of your own way, because the real actors in your production are your client that you represent, and also your witnesses and your experts. So you're there really to bring the story to light more as a narrator than anything else. Because if you bring anything more than that, if you're over the top, jurors tend to hold that against you. Here we go. All right. So one of the in my estimation, one of the most important parts of trial law, and also using your skills to your arts skills in trial or as a lawyer, is storytelling. Why? Because just telling a story is engaging to the audience. Think about those times when maybe, you're listening to a speech, or you've given a speech, and you throw in some sort of anecdote in there, that people can engage with, but also that people can relate to. It pulls the audience in when you're actually telling a story. That's the best way, or the best format, really, to really do any presentation at all. And again, and this is because you're creating that human connection. You're not just a wall, spouting out facts and spouting out information. You're telling it as a story, which makes it more interesting. Believe it or not, when you tell something as a story, and this, you can think of this actually as from a marketing perspective. Think about, the most effective maybe commercials that you've seen. You are enhancing the recognition of the purpose of what you're talking about. So we call that brand awareness. When you're telling something as a story, people are able to, again, relate to it and understand what you're saying, and more so the why. We've heard about, follow your why. Why people don't buy something from you because of what it is necessarily, but oftentimes why you're selling it, why you're doing what you do. And it's the same with what we're doing as lawyers. A lot of times people aren't really relating to what we're telling them. Like, sure, Mrs. Smith got into a crash and she's very badly injured. Okay. But why we're here, why we're asking for help. That's the part of the story that is the most engaging part of the story for your audience. Storytelling does influence decision making. It drives engagement and loyalty. And this actually translates right to your marketing as well. When you tell stories, right now I'm one of these people that's getting very sort of fed up with meta, and the algorithms and all of the things. And, we're bringing in professionals to help us navigate that, which is always a good idea because I'm good at a lot of things, but figuring all that stuff out, I'm not. But what I find is the videos, at least lawyer videos or vendor videos that show up in my feed and that I relate to or that resonate the best with me tell a bit of a story. And I will watch the entire thing. I'm like, this is really compelling. This is engaging. So that's one of the reasons why storytelling is so important across the board for us as lawyers. And again, it strengthens the internal and external communication. When you're telling a story, a lot of times people aren't necessarily picking up every word that you're saying. Our brains don't work that way, especially now, especially with the fact that most of what we're dealing with is, we're the rise of the TikTok generation. We don't have the same attention span that we used to. And truth be told, I have always had the attention span of a squirrel. And, that's just how my brain works. Being able to make that connection to a person, make that connection to your audience strengthens that bond where they're more likely to pick up more of what you're saying. So when you're giving a presentation, a lot of my colleagues will say, especially in the medical malpractice field, will say, but we have so much information that we have to give them, and it's all technical and it's medical, and it's very important that a jury understands all of this. The difference between giving facts and just listing a bunch of stuff that's, obviously important versus giving it the form of a story is that your brain, this is actually kind of some quasi-scientific here, that storytelling causes the neurons of your audience to sync with the storyteller's brain, believe it or not. They start experiencing the same emotions that you are putting out there. So if you're telling a story and, your voice is quiet and you're getting to the point where we're talking about how, Janet was in this horrible crash, and as a result, she has experienced terrible injuries, including permanent injuries to her spine. They're like, okay, she's in a lot of pain. They're like, okay, we're with you. And then you start to tell about the disappointment in her that she was unable to attend her daughter's first recital because she just couldn't sit there. And how she, dreamed of this moment of watching her little daughter on stage as a ballerina because she herself danced her entire life. And this was a dream of hers, and she's unable to do it because she can't sit that long. That level of disappointment, that sadness that you're basically showing and telling the jury, they start to feel that as well because there's a story involved. It's not just saying, and she doesn't feel so good every day, and she's in a lot of pain, she's missing out on stuff. Like, that's not nearly as compelling as telling the actual narrative story. So you're engaging the audience. However, legal rigor versus artistic license is important. It's really important to balance your facts with your storytelling. And again, this goes back to what I told you about what our jurors will tell you, which is that if you are faking it in any way, if you're overstating anything, if there's a level of woe is me to your story, or if you say anything that's not true or not provable, if you're in front of a jury, if it's not provable later, you do so at your own peril. So the important way of doing this is really balancing the facts that you have with the story. If it's overly dramatic, if it's, if it's not based in fact, if it's not based in the truth of your case, you're going to suffer the consequences later. So that's an important, thing to keep in mind is, don't BS. It's got to be true, You can tell a story. And I know, I'm sure in your lives, you probably have that one person that, like, maybe is an uncle in your family who tells the same story at every holiday, and like every year it changes, and then the fish gets bigger, and whatever happened is, he's doing it for effect to get funny. You don't want to do that. That's obviously not something that you'd want to do as a lawyer in front of a jury or a judge or anybody else for that matter. So there are different types of storytelling. I'm going to focus on storytelling a little bit first, because I think that's really where that translates to really any area of law that you're practicing, because you can be doing these things as a plaintiff's PI lawyer like me, as a defense lawyer, even if you're on the dark side, that's okay. Doing commercial litigation, whatever it is, there are types of storytelling that you can use that will help enhance your story. Now, again, these have to be true, and they have to actually relate to the facts and what's going on in your case. But the first one, which is very common to use, is the hero's journey. It's the person that, think about the hero's journey as like, everything's going great. I always think about, one of my favorite hero stories is the Lord of the Rings stories, and the Hobbits, and thinking about, taking that ring to Mordor and all the things that they had to do. But the hero's journey, I mean, it's up and down. Things happen, and they oh my gosh, are they going to succeed? Okay, so, they're building back up again. They're building back up. Yes, they're doing it. That's the hero's story, and when they finally win at the end. The hero's journey can be told and can relate to a lot of stories. I mean, in particular, it's one, if it makes sense to use, I use in my cases. And the reason why is because we found, and this is, through doing all these focus groups, is that what the jury relates to, particularly in a personal injury case, is a hero, heroes and villains, versus victims. We'll talk about that a little bit more in a sec, but that's one of the reasons why I use that story, because I think that really does help tell the story of my client who has overcome everything, and despite a life that she didn't bargain for because somebody wasn't paying attention on the roadway, she's doing everything that she can to overcome it, and she's still volunteering at the church or whatever it was that she's doing. So those are those kinds of stories. Rags to riches stories are great in commercial litigation. My youngest sister is also an attorney, and she practices. She's a great trial lawyer also. She does some personal injury. She does a lot of personal injury, but she also takes on commercial litigation. She kind of changes hats, and she does defense work with that too. So a lot of times, the companies that she works for, that she represents, are getting sued for various reasons, and she's been able to use some of these storytelling methods to help in her trials for commercial litigation. And the rags to riches one is great, especially if you've got a startup, especially if you've got a mom and pop type operation, or maybe it started as a mom and pop operation. And you could probably even, make, rags to riches stories pretty easily with Apple and with Amazon. Or you think about, these companies that started in their garages, a little less relatable these days, but back in the day, I'm sure, those all make sense. Even Instagram, Facebook, Meta, Zuckerberg. I mean, these are people that started. Granted, he was at Harvard, so I mean, how rags could he really have been? But the reality is that these are people that have an idea that they're starting from nothing, and they raise themselves up, and they became successful, only to be sued by some guy who is unhappy about something. So there's that aspect of using those kinds of stories. Into the middle of things and the false start, plot twist are kind of related in a sense. Into the middle of things is a story that you can tell where everything's wonderful, everything's great, life is perfect, life is wonderful, and all of a sudden, somebody throws a monkey wrench. So whether that's related to business, whether that's related to an injury, that's something that happens in those kinds of stories. The false start plot twist one is interesting, and it usually happens when the plot twist happens. Actually has happened in my sister's cases in commercial litigation, but I'm going to talk about a case later on that there was a bit of a plot twist in a very serious personal injury case I handled many years ago, but it was the one that comes to mind immediately. This sometimes happens while you're at trial. This sometimes happens while you're in the discovery process. So in New Jersey, for us, we don't we have an ongoing discovery obligation, meaning if we find something, whether it's a document, something comes into our possession, we have to share it with our adversaries. There's no In New Jersey, however, we're kind of cut off. Federal court, you're kind of cut off as to the time that you can continue to bring information into a case. But sometimes those things happen after a deposition. You find that there's a plot twist. Like suddenly you find either there's somebody else new that needs to bring into the case, or information you didn't find before. So you can lead your story into a certain point and then take that left turn and say, well, everything was going this way until this person came into the case, and now this is why we're here today. The mountain is kind of like the hero's journey. If you're thinking, think about the hobbits again, trying to climb up to the top of Mordor. And by the way, I am a big nerd, but there's a lot of those references in there, so make of it what you will. But the mountain is sort of there's what would appear to be an insurmountable obstacle in the way of your client, in the way of their progress. And it could be this case. It could be the case that you're handling. This is the mountain, and you're asking the jury to help, give them a path through. And you should write that down, because that's actually a good statement I just came up with off the cuff there. You're asking the jury, we're asking you for help to help our client, get through the rest of her life. We're looking for a path through the mountain or over it. Spark lines are sort of like thematic, like the I have a dream speech. Those are ways of more so telling presentations and telling speeches, but they work really well, particularly in oral argument, believe it or not. We always have this formula, I think, when we go to oral argument, we go to, we're arguing summary judgment or whatever it is. And sometimes when you've got a theme in your case that really works, not that you want to be smoked out necessarily before trial, but sometimes that happens anyway with summary judgment. So go ahead and use it, and start using that, that theme, whether it's, unfortunately in a case like this, Your Honor, here's a popular one is, unfortunately, Your Honor, the defendant was more worried about profit over the safety of its own people, and that's why this happened. That's why we're here. Things like that you can use. So, writing your story, the story of your case, the elements that you need to use. I think we probably all learned this. Most of us probably learned this in grade school when we were learning how to write and creative writing and writing our stories and whatnot. But it's important, particularly if you're a trial lawyer, to tell the story right off the bat in a compelling way in your opening statement. For me, as a plaintiff's lawyer, that I do primarily truck wrecks, auto accidents. I do premises liability type stuff. My opening statement is generally never more than 20 minutes at most. I did have a very complicated sexual assault case with a lot of moving parts in it. That one might have been 45 minutes, which is a lot for me, for an opening. But generally, you want to be able to be succinct in an opening statement. If you're giving a presentation for arbitration or mediation, you want to be able to give your preliminary statement. This is a great way to think about how to do it. So how do we do it? Well, your story has an introduction, right? This is where you're going to set the scene. And here in my world, this is where I put the rules in there. So and those of you who do personal injury, if you're familiar with David Ball and damages, I give him full credit since 2006. When I first learned how to do this, I have been using the David Ball opening outline as my opening. I've zhuzhed it up a little bit to make it my own, but by and large, this is how I do things. So when I start with the rules, and I might say something like, in New Jersey, all drivers are required to pay attention to the road and watch where they're going. And if they don't, and they cause and as a result, someone is injured, that driver is responsible for those injuries. It's simple. I'm not going into the statute. I'm not going into, NJSA 97 colon and blah, blah, blah says, no, I'm just setting the scene with the rules. The rules are people need to drive and pay attention on the road. That's the rule. And if they don't, and somebody gets hurt, then that person's responsible. Simple as that. So then you go into the conflict. And by the way, the rules could be set for anything. It could be, you could be the defendant, in a medical malpractice case, talking about the standard of care, or a plaintiff talking about the standard of care. You could be, in a commercial litigation situation, talking about contracts. And, in New Jersey, if you are doing a certain thing, it has, everything has to be in writing, whatever it is. You can do that right off the bat, set the stage for what the rules are. Because, you think about it, my daughter used to love coming to me with games. And I grew up playing games. I have two younger sisters, and everybody cheated in my family, to be honest. But so when we would come up with a new game, what would happen is one of my sisters would be like, don't worry about the rules. We'll figure it out as we go. They would make up the rules so that they would win. Well, we don't want to do that. We want to give everyone the rules so everyone's on the equal playing field. So, when my daughter comes to me and says, oh, Mom, I got a game. I want to show you this game. I say, okay, tell me what the rules are. It's the first thing I want to know is like, how do I play this game? What do I have to do? Tell me the rules. That's what you're doing here. Your conflict. Why are we here? What's the problem? You want to talk about, in a succinct way, what's going on? What are you doing here? What's happened here? And not just why, what, but why? Why are we here? What is this? It's okay, somebody got a crash. Well, big deal. Like, why do we have to be here? Why are we involved in this? Well, you're involved in this because, we need you to resolve, whose fault it was. That's the conflict in a case like that, for example. Your climax for your story that you're telling is really the key evidence. This is the turning point. Well, we say it's the turning point. I mean, it's a little bit anticlimactic in a lot of if you're doing trial work, because we know what the outcome really is. But for someone who's hearing the story for the first time, it could be that point where you have your expert up on the stand, and basically saying, blowing up a picture of, a slide of an MRI showing like the size of a barn door, showing, that this is where the damage to the spine is. This is the herniations. This is where there's impingement on the spinal cord, whatever, where the jury can look at it and say, okay, we get it. Now we understand what we're doing here. This looks bad. That could be your key evidence in a case like that. It could be, it could be if it's a document type case in a commercial or, a corporate kind of a case. It could be we call it the case cracker, the smoking gun. It's that piece of email or that recording or whatever it is. It could be a video, something that shows that we're telling you the truth. This is what we've been saying all along. Now you understand why we're here. And then resolution. That's really in your closing arguments, in any, whether it's a trial or not. How can the judge help you if you're in front of the judge? How can the jury help? What's the resolution? How do we wrap this up? Okay, all these bad things have happened and it's terrible, but what do you want me to do about it? What are we doing here? So you've got to be able to give the jury or whoever you're presenting to a way out, way to help the situation and make it better for you. So we like to say that art expresses human experience, and trials do the same thing by drawing a jury into your story. I grew up, my father was an attorney also, as well as a guy who ran a theater company. So the apple didn't fall far from the tree, but he wasn't the kind of lawyer that I am. I mean, he was back in the day. My dad graduated from law school in the early 70s and practiced in the 80s and into the 90s. And he, it was sort of, everybody did a little bit of everything. We used to joke that he was and we owned a farm too. I grew up on a farm. So we used to joke that, that the country pizza lawyer commercial. I don't know, forget which pizza place does it, but my dad's just a simple country pizza lawyer. Because he could do anything. He could go milk the cows, and then he can come in and he could do a closing in real estate, or he could handle a personal injury case or handle your divorce or do a will. He didn't really have the same love of the law that I do. And I think part of the reason why was because he didn't really find his niche. There was really no niche where we grew up in his practice. So, but in talking to him, now that he's been retired for quite some time, and talking about some of the trials that he did very well at trial. And he said one of the reasons why I was able to do well at trial was that, I was able to bring the jury into the story. Because where I'm from, I'm from a relatively rural area, believe it or not, in New Jersey, a lot of farmers, a lot of farms. Their life experience as jurors was limited. But if you could relate to them in a way that made sense, they were very, very generous, because they understood the value of a dollar for sure. So drawing them in, using these presentation skills, using a very, very relatable story will help at trial, no doubt. So as you're getting ready to put your cases together, one of the things that you need to do, and this is really from the very beginning, is develop your characters. This is something I do pretty early on, in the pretrial stage, certainly, but definitely in the discovery stage. You need to develop your characters so that we understand their story. That's kind of, figuring out who they are. One of the things that I find very important, as a PI lawyer, is going to my clients' homes, learning about them, learning about how they live their life, post-accident, learning about how they lived their life pre-accident, and getting an understanding of what's changed and what's different in their life. But developing your client, like as I said before, it's for me, I don't want anyone to be a victim. I generally don't take clients whose lives are over because they got rear-ended in the Stop and Shop. That's just not the kind of cases that I'm going to take. I want someone who does feel like I don't want to give up. That's really important to me. Your client should be authentic. If they're going to get emotional, whether it's at their deposition, whether it's on the stand, it should be authentic. If you're coaching them to say, listen, if you can throw in a few tears here and there, that would be really, really good. Everyone sees through it. It's got to be authentic, and their client has to be authentic. You have to figure out who your witnesses are and what purpose they serve, both your witnesses and the witnesses that you're going to cross-examine. Obviously when you're putting your case together, you're going to try and figure out who you need. So, for my purposes, I want to have a number of lay witnesses, not just family members who still kind of have a horse in the game, but people that are from work, people from the community that know my client, that can testify as to how he or she, was before or after the accident. Experts, same thing. I mean, your experts really need to serve a very specific purpose, obviously overcoming, standards, and legal standards, but also theirs. If you're in a case where you're dealing with, medical malpractice, a lot of times, medical malpractice, and I don't generally practice medical malpractice. I assist on those cases. Those aren't cases that I take, just because they're just outside of my wheelhouse. But a lot of times you might use the defendant doctor as your first witness, kind of taking them as a hostile witness. And because you're deciding that, we know who this guy is, but we want to set the stage with what he didn't do that set the stage for what happened in this case, perhaps. Same with their experts as well. We have to figure out who they are and what role they play. Your adversary. I'm pretty lucky in where I am or where I've gotten to over the last 20 some odd years in my career that, when I was a younger lawyer and, relatively inexperienced, my adversaries would do whatever they could to make me feel my age or my experience, which was pretty crappy. But they also would be nasty. They would be these, and I would be like, God, I can't wait to go to trial because this person is going to be so bad. And oh my God, they're just going to turn the jury off. And then we get to trial, and it's like my sweet grandma is now the defense attorney. Like, who is this person and where they come from? So one of the things I always recommend is forget about that person. In my best New Jersey, forget about it. The adversary's role in your story is really just the person who is hiding the truth, perhaps. What I do often, that is the case. Hiding the truth from the jury and from, from whoever needs to hear the truth. They don't send them to the right doctors. They don't send, important MRI films to their doctors to look at. That's the person. But I don't refer to them by name. They are just the defense lawyer, the defense lawyer, the defense lawyer. That's who they are. And they can be nice as pie, and a lot of times we get along great. In fact, I get, by and large, it's very, very rare occurrence that I don't get along with my adversary, because what are we doing? It doesn't make any sense to, be nasty, unless, you get nasty with me first. I might get nasty, but there's no reason to be, scorched earth. We're trying to resolve a problem. You've got a problem in a client. I've got a problem in a client. Maybe we can resolve it here, or maybe we can have some strangers to help resolve it. But either way, it doesn't work to be nasty to each other, particularly in front of a jury, by the way. That never looks good. And I think most experienced defense lawyers know that, which is why they sometimes change their costumes when they come to trial. They become new people, in my experience anyway. You also have to know who the jurors are. Know your jurisdiction, know your venue. Do focus groups, figure out, who would be the best juror for your case if you're dealing with a jury. But everyone is going to be serving some role in your story. And a lot of time the jurors are just, they're your captive audience. I mean, they probably fell down the rabbit hole when they got stuck, getting chosen for jury duty in the first place, probably weren't even really expecting it. So, be mindful of that they're there to hear something that's compelling and interesting in order to want to help you. Writing the client's story is something that you can do right from the very, very beginning of your case. It sounds obvious, and outside the obvious, but at intake, you want to ask the right questions, not just the obvious questions that you need, but also things like, how does what has happened change your life? I always tell people, when you think about the scales of justice, in a PI case, the scales of justice, like you're going about your day like this, and all of a sudden something bad happens. And this goes for everything. And now what you're asking, a jury to do is balance the scales. That's what compensation means. So there are changes in someone's life, whether it's their business, problems with their business, whether it's, personal injury or whatnot. So what you need to figure out is what those changes are and how. And also find out who else has been affected, in their story. Have their children been affected? Have their family been affected? Has their work been affected? Who else can we talk to? And the reason why is because, again, we're trying to develop our characters and bring in more people to be part of our case. And then you also want to ask your clients, what do we need to do to help you? And explain to them, from the beginning, we're going to be asking, hopefully this case resolved before we get to trial. But if we go to trial, regardless, we're asking an insurance adjuster, we're asking a defense attorney, we're asking the judge, we're asking whoever to help us in some way, either, dismiss this other person's case or help us with money or whatever it is. So what can we do to help? How do we get there? And also, especially in the case when there's money, how does money help? How does money fix the problem? Because usually it doesn't. And I can tell you from experience that my personal injury clients will tell you that I never wanted this. If I could just go back and not have the day-to-day pain that I have, I would take that. The money is not important to me, but here's how money could help. And they will go through and say, well, I can't mow the lawn anymore. And my wife she's not able to push the mower. So, we could hire somebody to come in and mow the lawn. We could, things like that, is something that you want to find out from the beginning and start thinking about it, because it helps the story be written. This is what I was talking about before. The victim versus the hero. And these are all pictures of my daughter when she was younger in various theatrical presentations. One of them being 11 from Stranger Things, if anybody else is a huge Stranger Things fan like I am. And the other one is SpongeBob, another favorite character of ours. But a person who overcomes adversity is much more compelling than a person who just, bad things happen and they give up and they say, well, that's it. I'm here, to ask you for jury for help because I don't know what else to do. I mean, that's not very compelling. So someone who doesn't give up, someone who keeps fighting, that's the person that, the story that you want to tell. So developing the hero story, you want to figure out what sorts of problems the client has to overcome. Um, what has she done to overcome them? That could be if you're in personal injury. That could be they have, they've done everything a doctor has said to do. They've undergone injections. They've undergone surgery. They've done everything that they needed to do to try and get better. It could be if it's a business situation. It could be, we try to mitigate our own damages, in this situation, but it wasn't enough. It didn't help. Whatever it is, because you want to give the jury or whoever it is that you're presenting to a reason to cheer. You want to give them a reason to want to help and want to, at the end, say, okay, we did it. We want this person to succeed. We want this person to overcome all this crap that has happened to them. So framing the story of your case, something that's very important is being clear and concise. I tend to be verbose in general. And one thing that I've gotten really, really good at from the time I was in high school writing, through my writing career, through law, is editing. You just got to get to the point. My daughter's favorite phrase with me is when I tell a story is, "Mom, land the plane." And I laugh. It's rude, but I laugh because she's right. Like, get to the point already. Get from point A to point B in the most structured, logical way that you can get there while still engaging someone who's either reading your paper, whether it's a brief, or listening to your argument. Just get there and be able to. The logical structure obviously has to include your citations, has to include facts and law, but really that, landing the plane is the way to get there. So creating a theatrical plot for your case framing. Here again, and this is sort of more detailed of what we talked about before. You're introducing your characters, and we want to know why they're important to the story. So if you are doing direct examination on your a witness, and maybe it's the husband of an injured spouse, talking about why they're important to the story, and why they're not just just the husband or just the wife, what part they play in the life of your client is very important. Same with, if they are a treating doctor, or, you're dealing with an employment law case, and, you're defending the employer against an employee who's citing, discrimination, harassment, whatever it is, why the other employees that you're bringing in, why they're important to the story, what they bring to the table. Lay out what the conflict is, what the problem is. You've got to talk about the liability. Why did this problem occur? What should have been done, what could have been done differently to have avoided the problem altogether. You want to know or talk about who's involved in that problem. Basically, that's your causation. Who or what caused that problem? Was it the guy on their phone who rear-ended your client? Was it was it the anesthesiologist who didn't follow standard protocol and forgot to empty your client's stomach before they were undergoing anesthesia? Who's involved in that problem? What's being done to solve the problem? So, in a case like this goes to mitigating damages. It goes to, in a lot of ways, it goes to, clients' damages is what's happening. What can we do to solve the problem? Well, Mrs. Smith is scheduled for surgery. She doesn't want to do it, but she knows that that's really the only way that's going to relieve her pain. Finding out all of those things. What is the solution in this case? Well, the solution could be you've got to find my client not guilty. If you're dealing with a criminal case, find my client not guilty because of all the reasons that we stated before. It could be, the solution could be we're asking for a verdict, in the amount of $1 million to help, put Mrs. Smith back to where she was before this crash. And then that ties into how that's obviously how it's solved. Like what does the jury need to do? What does your arbitrator need to do to solve this problem, to solve this case for you? One of my favorite movies, one of my favorite obsessions is severe weather. And living in New Jersey, we don't get a lot of tornadoes, although we do get them once in a while. But growing up, I had three fears: venomous snakes, which we do have venomous snakes in New Jersey. We have rattlesnakes and copperheads, and nuclear holocaust. Obviously, I grew up as a child of the early '80s, so the Cold War was still ongoing, and we were still doing it every so often. We would do a drill early on when I was little. Um, Nuclear holocaust, and then tornadoes. In fifth grade, I had a teacher who was my science teacher who came from Kansas, and told us these like horrible stories about tornadoes in Kansas. And the reality was, because of Kansas and how vast it was, he really didn't experience what he was telling us. I learned that later on. But nevertheless, it created a fear in me that really was unfounded, but there we were. And anytime I was very afraid of something, I would learn all about it. And I would write reports on things, even if no one asked me to write a report. So, surviving nuclear holocaust, I got it. Anyone that needs any questions about that, don't worry, I got you. What happens if you get bit by a snake? I'm on top of that one. And tornadoes. I know how to deal with a tornado, how to handle myself, and what to do. Now, one of my favorite movies out there is Twister and Twister 2. And knowing all that I knew about tornadoes, I went into this movie like, okay, like I got this, like I know all this stuff. And a lot of what they put into those movies were very scientific and very fact-based, based on what I knew. But one of the things that annoyed the crap out of me, especially in the first one, and they did it again in the second one, was the way that they explained things. So as lawyers, we know a lot of big words. We know preponderance of the evidence. We know causation. We know words like, if you're doing spine cases, words like spondylolisthesis. So if you can say that, good for you. But really, those are words that we should not be speaking when we're in a courtroom or really anywhere, even to our own clients. It's in the papers, it's in the in all the documents, whatever it is. But we don't need to speak those words. We need to use common language that does not require mental gymnastics to understand it. So the reason why I use Twister and Twister's dialogue is that they needed to explain a lot. There's some scientific technical stuff in there, but the way they wrote it into the script for me, and you'll have to go back and take my word, or take my word for it, but go back and watch these movies. The way that they explain these things, in these movies, like they almost over-explained it. It was very easy to understand, is the point. So I'm not saying dumb things down. Not at all. Our jurors are savvy. They know what you're talking about. But if they have to use mental gymnastics to understand what you're saying, they will absolutely tune you out. They will hear nothing that you've said. So learning to use, and again, this was the editing, learning to use common language that everybody understands will get you to get your story across much, much better. Use language that speaks to senses. These are our senses: sight, hearing, touch, taste, smell. If you're describing the scene of an accident, or ask your client to describe it when she's testifying, what did you hear? What did it look like? Did you smell anything? Yeah, I smelled smoke. I thought my car was on fire. I smelled the chemical smell when your airbag goes off. Use that in your presentations, but also use it, in your writing as well, because it'll help connect people to what you're talking about. So now we can get into some of the theater skills to consider as a lawyer giving your presentations. We talked a lot about writing and presenting in that regard, but there are some things that we can consider as actors. Acting skills and improvisation. Actors are generally pretty sharp on their feet. Obviously they're relying on a script. They're relying a lot of times on words that someone else wrote for them. But you're on your feet, and this is where it helps us as lawyers. Being able to be on your feet, being present, being in the moment, not being distracted. Our phones are like, they're absolute albatrosses around our necks these days. And it's constant contact. Like, no matter what it is, someone's texting you, someone's emailing you, someone needs you immediately. Like, it's overwhelming. But being present, being in the moment, and being able to close out all of those other things, those outside things, and focus on the story that you're telling, on the presentation you're giving, is actually an acting skill. And it's important because if you're not there, if you're distracted, if you're in the courtroom, even with the judge, if you're in the courtroom and you're in the middle of oral argument and you're not just sitting there with your pencil and your pad and you've got your phone going or you're on your computer. I've seen lawyers do this before. Like, it doesn't look like you care. So even that perspective or that impression of you, being present is very important. Listening, so important. You know, one of the things we have to do as actors is listen for our line so we know our cue. Sometimes when you have your client on the stand or you're cross-examining, we're so used to, like, we have our script and we're going through the list of questions we have. Okay, we got this, and we forget to listen to what they say. Because a lot of times there's some follow-up that you can make, or your client is going off the rails for some reason, and you're like, you got to bring them back. Or you're cross-examining the expert and they've said something like ridiculous or not true, that you can verify and you can impeach them on it. So listening is very, very important. Staying in the moment and listening. Being prepared, knowing your case. I mean, you'd be surprised, maybe you won't be surprised, how many lawyers, I'm always surprised, in what I do, lawyers will show up to court, whether it's a case management conference or something, and they don't know the case. And it's like, this is the first impression you have with the judge. They're eyeing us both up and like, well, the short lady knows what she's talking about. She doesn't even have papers. She's got no notes, and she's telling us what's happening in this case and where they are. And this person's over there digging around for, something that they're, in their file. Being as prepared as possible. Like when we go into a show, for example, as an actor, and I'm putting on a show, we all know our lines. My dance students right now are preparing for their holiday showcase, and one of the things I put in my notes to them today was, Sunday is dress rehearsal. You better know all your dances because there's no do-overs. Like, this is it. You get one shot at these things and you can't do it over again. So it's important to really, really be prepared. And by the way, that's my daughter. She's an actor. It's one of her headshots. Acting skills that connect you to a jury, eye contact. In this contact, obviously, it's hard. I'm trying to make eye contact with the little green dot at the top of my screen, as best that I can to try and make eye contact with you guys, but it's very difficult. But making eye contact, not in a way that's creepy. Sometimes, people get a little weirded out when you're staring at them. But, you can look at them, look away, look above them, look around them. On the stage, in the theater, you don't really look directly at anybody necessarily. You're looking sort of around and above them. And you can do that while still stopping for a moment and making eye contact. Your pace is very important. When you are consistent in your pace, I'm from New Jersey. My brain works way faster than my mouth, and I talk very quickly. I know that, especially when I have a lot to say. So it's important to slow down, especially when something's important. Slow down. Take a minute. There is power in silent moments. Sometimes we get nervous and we feel like we have to fill the void with words. Don't. Pace yourself. Take it easy. And then authenticity and grounding. If you've noticed, if you're into movies or you're into theater or you're into TV, whatever it is, you notice that the acting, if you compare the acting from the 80s, even better example, the 60s, the 50s and 60s, when, you had your private investigator, and they talk like this, and, private dick, and no one talked like that in real life, but that was a voice for some reason that they all had, back in many, many years ago in old movies. It's not authentic. Nowadays, we are grounding ourselves, as actors. We are being very, very, there's not a lot of overacting anymore. I mean, there is if you watch certain, Disney Channel kind of things for little kids, but by and large, even those are becoming much more grounded, more realistic. There's no reason why you can't talk like a normal person. There's no reason why you have to put on your own character, when you're presenting anything. So authenticity and grounding is very important as an actor. Back to controlling pace. And that's me. One of the hardest races I ever ran back when I was still running, the North Face endurance challenge. The pace, just like a runner, your pace is what's going to get you through whatever it is you're doing. when you control your pace, you can accentuate important points. You slow down, like I just said. You can focus on the strongest facts. You can make sure everyone is getting what they need to get. If we don't understand, we don't hear. That's sort of the end all be all. If they don't understand what you're saying, because either you're going too fast or you're saying too many words, they're not going to hear you and it's going to be lost. So controlling the pace will help everyone understand exactly what it is that they need to understand. One of the important aspects of acting is obviously communicating. Whether it's, a serious message that you're communicating, lines in a play, the storyline, the plot itself. One of them, and as a lawyer, of course, one of the most important things you can do is know your audience. I said before, I write plays, I write comedies. Most of them are mysteries or murder mysteries because they're a lot of fun. But I write them, many of them, with sort of local and hyper local stuff in it. And the reason I do that is because I know my audience, where I live and where I produce. These are people that are looking to have a good time. They're not really thinking about much more than, going out and trying to solve something or having a nice social night with their friends. They're not really worried about trying to solve the world's problems through a theatrical performance. When you know your audience, you know what will resonate with them. Same with your jury, same with your judge, your mediators, your arbitrators. Do your research. If you get your jury, and this all varies, state to state, but in my my venue, sometimes we can get the jury lists ahead of time. Sometimes we're just showing up and we're doing our best to research them as we go. Why we do that? We go on social media. We look for posts. We look for, who they are and what they say they are. We get very, 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 and I say very little voir dire in New Jersey. That's allegedly about to change. They're looking in New Jersey to change the court rules and allow us to actually have an active voir dire or voir dire, as my Southern friends like to say. That will help us. But at the very least, knowing where your audience is from, if you're a jury, for example, the towns that they're from, what they do for a living, you can kind of get a sense of who they are. So some things that you might have prepared to present or say may not resonate with this group because, they're not going to have the same experience that you're talking about. You've got to find a way to relate to them. Knowing your subject, if you're in a show, you need to know your show. You need to know it, not just the lines that you're delivering, but also, you have to know what the movie's about. You need to read the entire screenplay. You have to read the entire script, depending upon what you're doing, because then you know what your role is in that show, and why you're important, what you bring to the table. Same with your cases. I mean, you really need to know your case, know it back, forth, left, and right, and know yourself. Know your limitations, know what you can, if there's anything that you struggle with that that I'm not great at, at saying a lot. So say the important things. That's really important because that's all that's important, right? Is the most important thing is find those things. You don't have to, BS your way through, either a presentation with a jury or with a judge. Develop your own technique. I love this quote. Usually when I have acted well, it's been by accident. I think that, that probably resonates well with a lot of actors. But, using technique, technique comes from just practice a lot, practice, in front of people, do focus groups, practice in front of staff, practice in front of your family. I used to set up my stuffed animals, when I was a young lawyer, and I would present to my stuffed animals just to be able to get my words out and hear myself saying those words. That's the best way of getting there, is really being able to continue to practice, the best that you possibly can. And that's how you develop, whatever technique it is, whether it's, your writing technique, and making things compelling, writing things in a compelling way, or presenting. So if you see the courtroom as a theater or a stage, you've got your obvious, parts of your trial can be related to the theater or the stage. You've got your opening statement that sets the tone and grabs attention. Direct testimony, that's how you're putting the story together and telling the story. Your cross-examination has to be the part of the story where you're maintaining control of the plot and you're guiding the narrative on cross-examination. I could do a whole program on cross-examination in this regard, but that's very important. And in your closing, you should be giving a memorable, powerful statement that pulls together all of the evidence and gives your jury a reason to help you. Again, it's got to be fact-based. It's got to be stuff you've proven or shown throughout the course of the trial. But that's where you're allowed, because that's argument. That's where you're allowed to be a little bit theatrical and use your skills and use your presentation skills and your acting skills to, again, be compelling and, compel the jury to do what you need them to do. So I'll tell you very quickly about this case, because now I realize I'm a little bit short on time. I had a case called Metzler versus Kurtz in New Jersey in 2009. We didn't know it at the time. When we took the case on in 2004, we finally got to trial in 2009 or 2003. 2009 was when we got to trial. This was a very serious sexual assault case involving an oral surgeon who would put his patients under and assault them in various ways. We didn't just have, we had one woman come forward and tell us this happened. And then without really knowing anything about, other than having it be in the paper, we had 3 more women come forward and then 4 women. And by the time we were getting ready for trial, we had 28 women. We only could represent, because of the statute of limitations in New Jersey at the time, we can only represent 4 of them. And as we got to trial, 3 of the cases, there were 4 cases, same doctor who did this, same other defendants, but 3 of them, timing-wise, the insurance policies that were written allowed for settlement for an intentional act. So we had to try the 4th case. And this case had everything from compelling story. And the reason why it was a compelling story is one of the things that we did was we kept all the girls separate. They never met each other. They didn't know each other. They didn't know each other's stories. But they all had eerily similar stories of what happened to them, how it happened, and what happened to them as a result of this. So it became a compelling story. It was anyway. It had a little bit of criminal aspect to it, but it was compelling. The characters were interesting because the girls, again, we kept them apart. We had this doctor who, when I tell you he's out of central casting for like a 1970s porn, not that I've ever watched a 1970s porn, but from what I'm told, this was the guy. It was, in fact, during his deposition that we recorded, his phone went off, and I swear to God, the ringtone was like bow chicka bow wow. It was terrible. But in any sense, we definitely had a hero versus villain dynamic going, although he was painting himself as the hero and these girls as these money hungry, horrible people. But we had heroes. Our girls were doing everything they could in their lives to overcome this, what turned out to be really terrible trauma. But we had a plot twist. Things weren't going so hot. It was really, really, it was quite a horse race getting through this case and getting into cross-examination. And one night I was sitting by the fireplace, and it was my ex-husband was actually my trial partner at the time. And we're going through stuff, and I'm like, what are we missing? Like, there's something that we're just not seeing. We're not doing a good job at, and I was getting sort of panicky about it. And I'm going through we have just police reports and all these things, and I find a name. I'm like, who is Susan Dennington? And why haven't we spoken to her? I start looking through. Susan Dennington had reported seeing something untoward happen. Oh, she was subbing as an assistant on a surgery, and she reported it to her boss, one of the partners in this practice. And then she disappeared. Have you ever seen the movie The Verdict with Paul Newman? Kind of like that. We had this weird eureka moment. We found Susan Dennington. We're in the middle of trial, by the way. We found Susan Dennington, and she said to us, I was wondering when you were going to get to me. Dun, dun, dun. Now, of course, that didn't make it to trial, that dramatic part. But the point is, we got somebody at that point. The plot was a complete twist because she came and says, everything that this guy is saying is bullshit. He's absolutely lying about how he does things, his protocol. Here's what happened the day that I worked for him, and here's what I saw. Now, it was still a horse race, but that's the kind of being able to start telling that story and using all the elements of the story. The fact that we had a plot twist is abnormal, but the fact that we were able to sort of capitalize on it at trial was very important, and it did, I'm sure, help us win at that point and get the verdict that we got for our young lady and help her move on with her life. So just some practical tips as I'm wrapping up here. Practice your storytelling techniques. Take acting workshops. They do help, especially with presentation. Go out for a play, audition for a play in your community. I bet you'd be really good at it. In fact, in a lot of the shows that I have in my professional theater group, I've got lawyers in my professional theater group. That's their day job. Take a dance class, go to karaoke, sing, write regularly. Journaling helps to improve your clarity and your persuasion. And something else, which again is a whole other area, but learn to use AI. The robots are coming for us. It's just a matter of time. So just learn how to use it, and it'll help you in everything that you do. So I hope you've enjoyed this presentation. I think I do have a couple of minutes left, but I hope you enjoy this presentation. I think that, overall, the synergy between law, writing, and acting is pretty overwhelming. And you should definitely embrace the art of persuasion in all of its forms, because it'll help you in everything that you do. If you want to reach out to me, them's my digits. Well, those are my emails, my websites that I have. You can look me up on Instagram. I do post a lot about my cats, but there's also law stuff in there too. My newest book is out. I'm actually gonna plug it because they told me I had to, for AAJ. This is a book called Experts: Picking, Preparing, Perfecting. There's a QR code if you're interested in it, but you can get that on the AAJ website. And that's it. If you have any questions, I think I'm happy to take any. But we're here cheering for you. I do these things, and I like to help out around the country, because, as they say, all boats rise with the tide. If we're not helping each other in this profession, we're doing ourselves a disservice. So I thank you very much for your attention and your time on this, during these holidays. I appreciate it.
Thank you so much, Lauren, for your presentation today. We won't have time to take questions live. So if you want to go ahead and contact Lauren, this is the best way to do so. That email is at the bottom of the slide. If you, for any reason, are not able to note this down right now, that is completely fine. You can always reach out to us at support.justia.com, and we can get you connected with Lauren if you need. We want to thank you all so much for joining us today for another Justia webinar. I also mentioned at the top of our webinar a really great resource for you, our website platform, Justia Elevate. There's a lot of AI features that can help boost your online presence, specifically for AI results. And our pricing starts at just $82.50 a month when paid annually. So if you'd like to check that out, elevate.justia.com/price. Thank you all so much for joining, and have a wonderful rest of your day. Thanks so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.